Good afternoon. My name is Eric Banks. I'm the chair of the Public Employment Relations Board. And thank you for joining us today for our first kickoff of our 50th anniversary celebrations. Today's panel is called PERB at 50, a retrospective. Today we're joined by Anita Martinez, Sean Clousey, Priscilla Winslow, Eric Shiners, and Loretta Vanderpool. For half a century now, PERB has been providing public sector labor relations to the state of California. We were created in 1976 by Governor Jerry Brown on the first go-around as the Educational Employment Relations Board. As the years passed with the addition of the DILS Act in 1978, the Educational Employment Relations Board became PERB. PERB continued to add statutes to its jurisdiction, with the most notable being in 2001 when we added the Myers-Milius-Brown Act, virtually doubling our jurisdiction. Since 2022 or 2023, every year PERB has now added a new statute. And 2025 was significant in the fact that we now, for the first time, received private sector jurisdictions with the TNC Act and AB 288, which I call the NLRB Trigger Act. So we are now at a crossroads in our growth as we decide what we are going to be doing and how we're going to be doing it next. So as we embark on celebrating 50 years, we thought it was important to spend some time to take a look back to where we came from with some of the people here who have been so instrumental in shaping this agency to what it is today. So we have a couple of questions, and the first question will be, first of all, as you're announced, would you please state your name and say when you were at the board or what you did? Some of you have had numerous jobs here. So I want to start off with that. And then during your time period at PERB, what would you describe as pivotal moments that you see shape the agency as it exists today? We'll start with, if we could, we'll start with Anita Martinez.
Great. Hi. So happy to be here. And this is the commencement of the celebration of 50 years. I was employed by the board for 40 years. So I saw a lot. And, I think that my remarks are going to be a little bit about the history in the beginning. Because I think other folks can talk about later stuff. I think I'm the only one here that might be able to go back to 1976. So I was hired in February of 76, and I came up to Sacramento from the NLRB, where I had been an intern for 2 years. And it was amazing. I was the fourth employee for the board, and we did have 3 board members. And what we did during the time of February to April was come together and put together regulations that we thought would help get things off the ground. That was fascinating because we had to make decisions. Was the board going to be like the NLRB model? Were we going to be a different model? And, the board did hold some public meetings to get some input. But we ended up with, the regs that are basically the ERA regs now. So I opened the San Francisco office on April 1st, which is when representation cases could be filed. When I say office, I mean it was a one office that was lent to us by the State Mediation and Conciliation Service. And it was in the State Building. And parties came in and filed their petitions along with their cards. And I had one support staff person who literally, I think the poor woman got some sort of hand injury because you had to timestamp them, when they came in. And it was very, very important to make sure that that was done. So that was the beginning. That was April 1. And, we hired staff. And at the end of the first fiscal year, we had 69 employees, which included 19 attorneys, 9 labor relations specialists. And I just found out that you have a labor relations specialist now, which is fabulous, because you don't need a lawyer to do all the work that is done by PERB. And so we had 9 labor relations specialists, and you're going to crack up at this. We had 31 support staff, so clericals who were typing. There were no computers. There was none of the tech that you're so used to and think of as, part of your existence. We had none of that. So we had what's it called? The pit? The pit?
It was the
Not the emergency room that most of you might know now, but it was,
pen,
I mean,
pen.
the pen,
Yeah.
the pen. And literally it was, rows of mainly women typing. So we had 31 of those at the end of the fiscal year. And I'm really proud to say that, going from 0 to 100, by the end of the fiscal year, we had conducted 113 elections statewide, which is amazing because lots of the folks that we hired had no experience in labor relations. And so those of us who did were basically the trainers on how you do it and what you do and what you don't do. So the first election was out of San Francisco, my regional office, and the case was Tamalpais Union High School District, which also became EERB decision number 1 because of the objections to the election. There were 3 disputed ballots, and then there was this whole issue about the media, because believe it or not, back then, having a statute for public employees, it was for teachers and, school employees, was a big deal. So it was covered in newspapers, pictures, blah, 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 blah. So I when I retired 10 years ago, I got rid of a ton of things that I had. And one of the things that I did not get rid of, I had a polling site in Tamalpais, and it was a high school. And this is a picture of myself and my 2 observers. And you will notice that my hair is to my waist. So you can tell that 50 years have passed. But it was really, really exciting because, to now have exclusivity and, unions vying to represent employees was a huge, huge deal. Everybody was used to the NLRB for private sector. People knew a little bit about the ag board for farm workers, but all of a sudden for school employees to be able to get exclusivity, it was a big deal. Let's see. So July 1st, so April 1st was representation. July 1st is when the first unfair practice charges could be filed. And by the end of the first fiscal year, we had 140 unfair practice charges that had been filed. So you can see that the parties were very anxious to get their disputes in front of us. And obviously, in order to become certified as an exclusive representative, they had to file the petition. So, we met a lot of folks. So this is also something that's very different from what you do today. The elections were all held on site, many with multiple locations. And LA Unified, for example, was a 3-day affair with 25 different polling sites, 30,000 eligible voters, certificated voters. And I got a flat tire on the way to one of my sites in the morning. But I drove the car with the flat tire and got to my site because it wasn't going to be on me that something went wrong. So the emphasis of the first few years, if I can just kind of synthesize it all, was the processing of repetitions, helping the parties reach agreement regarding appropriate units, the conduct of the elections if there was no voluntary recognition, which, employers could obviously do, The conduct of both representation and unfair practice settlement conferences with a strong emphasis on the parties reaching agreement. All of our meetings, elections, settlement conferences, and hearings were held in person, typically at the employer's work location. In the ensuing years, when DILS and HERA were enacted, again, there were unit determination hearings by ALJs, and then the board came out with final decisions. And I think that staff, this might sound kind of weird, but we're very excited about the different statutes that we, had to implement because they involved such different employees, different locations. And both of these statutes, I think, presented novel issues, many work sites, and the introduction of statewide bargaining units. It might be hard to believe, but we did the statewide elections by mail. We counted each and every ballot. And so there were thousands and thousands of ballots. And so we had a number of temp employees, but we got it done. And I think everybody, and I think that this is something that you'll find with PERB employees. They really are true to their job. I mean, they take great pride in the job. And when we didn't know what we were doing, we talked to each other and figured it out and went on. So that's something that I'm really proud of. And some of those ballots were counted in this space. So just to sum up, I think that board unit determination decisions were pivotal moments because they provided powerful guidance to the staff and the parties and led to the establishment of union exclusivity and representation of employees. So those I think are novel, interesting to me.
Thanks for doing that. Well, and I want to say to my staff, she is not a plant for hiring more LRSs. I want to say, she and I agree on this, but
yeah, you don't need a lawyer
no.
for everything. You really don't. And settlement conferences, investigation of unfair practices, we ended up doing it all. And, again, there were 9. And then all the temps that we hired were not lawyers. So, I mean, we used the ALJs to hold hearings, obviously. But
yeah.
Anyway, okay.
And I think the typing pool now is where information or IT is now based. So so the history now is being repurposed now for that.
Great.
I didn't have a plan to call on people, so I'm just going to ask you to jump in.
I'm going to jump in.
You do it.
Okay. I will introduce myself in a moment, but I'd like to say that I was a practitioner at PERB in the interim time between when I was an employee here. And I always looked forward to having a settlement conference with Anita because she got it done. She was a great settlement judge, among other things. And I just wanted to highlight that part of your career because you didn't. Anyway, should I jump in with my shtick? Okay. So I'm Priscilla Winslow, and I've had 2, now 3 go-rounds at this agency. Currently, I have the great honor of being a retired annuitant with the SMCS, so I'm learning a new craft. However, I started my career as a board counsel to the then chairman, Harry Gluck. I started in 1979 and went through to the spring of 1983. And the pivotal moments that I recall, well, let me just set the stage for what it was like to work at PERB then, kind of riffing on some of the things that Anita said. We didn't have a hitching post for our horse and buggy, but we were in a different building. We were in the building at 12th Street and J, a brick building that's kind of still there, I think. And then we moved here, I think sometime in 1980. Right. There were 3 board members, as Anita mentioned. There were 2 board counsel for each board member, possibly in recognition of the fact that the board had a lot of work to do initiating or implementing these 3 statutes. The staff in Sacramento was so small that we pretty much all knew each other, and we were able to field a softball team in the in the city league. That was one of my fondest memories, playing softball with Bob Kingsley. And the thing that was great about working for PERB then, as it continues to be, is that all of my colleagues at the time were, I think, shared the feeling that we were embarked on a mission, basically, to shape the labor law of these newly enacted statutes, and it was a very exciting time. So pivotal moments. We had to determine the scope of bargaining, what's in and out. And how do you interpret that statute that says wages, hours, and working conditions, and things that are related to the enumerated conditions of employment, and then enumerates those conditions. So most practitioners know that resulted in the Anaheim test that was ratified or approved by the state Supreme Court with the Healdsburg and San Mateo decisions. And of course, I assume that's still good law, Mr. Banks?
Yeah.
Yeah. Good.
Ish.
Okay.
I think it's been tweaked a bit.
Then we also had to confront the whole gnarly issue around strikes. Are strikes protected at common law? Are they not protected? Are they permitted by ERA or prohibited by ERA, et cetera? In preparing my remarks and going back through some of the materials that I have about this, I realized, or I was reminded, that PERB in fact held that strikes were protected, or no, it held that strikes did not violate common law 3 years before the Supreme Court came out with its decision in the county sanitation workers case. That was in 1985, and we issued the decision in Palos Verdes, number 195, that held that it did not violate common law. Anyway, after county sanitation came out and our Palos Verdes, then the question came, how do we seek injunctions, or do we seek injunctions? And when is it a violation of the statute as opposed to just being protected by common law? San Diego Teachers Association versus the Superior Court pretty much settled the notion that ERA does not prohibit strikes, but it was up to PERB to determine, as a matter of initial jurisdiction, whether a strike would be an unfair practice. So that was obviously a pivotal case that, again, still stands, I think. The other cases that I remember being very important during that era was establishing the test for evaluating interference charges and discrimination charges, resulting in the Carlsbad and Novato cases, respectively. So maybe I'll just stop. I have other stuff to say from when I was a board member, but maybe I'll just stop for now. Is that okay?
Sure. Great.
Okay.
Mr. Klausy.
Yes. So I was hired as an administrative law judge in 2007, and that was when the Schwarzenegger board was in. And I can say, I remember Anita Martinez getting appointed as the chair, and we were so thrilled that we knew there was going to be a sea change. And Anita is a very neutral person. She's a very fair person. And we knew the trickle down from that would come. And it really was a certain time. Sorry, Anita, you'd never say this, so I'm saying it. It really was a time of a lot of hope. And in a sense, a certain renewed vigor in regards to an approach to this area. And being a former employee and now the chair appointed, it was like perfect. And it was really an exciting time that we had there. I was a practitioner also before that time. But I'll say, during Anita's time, budget time was hard. And I remember we had 6 judges forever and ever. And I remember going to a budget meeting with Anita and begging for crumbs. I mean, literally, that's kind of how it felt. And we got a crumb, we got a seventh judge, and then it got taken away. And this is while MMB is just on the scene and taking on. And you got to remember I'll just say the time of, let's say, the Great Recession, 2008. And you can bet cases are not settling during that time. And the need for resources was absolutely tremendous. So I and Anita, in my mind, took all the efforts to make that sea change happen. And I think you were successful, Anita. You would not say this about you, but so I did want to say, as time went on, Chair Gregerson took over, and he really wanted to get some nickels and dimes for our agency. And he did, but we had to go through, I shouldn't say had to, I think it was a voluntary case processing efficiency initiative. That was a great, that was really a great experience for an agency to look at itself, to say, what do we need to change? How can we do these hearings better? People were so open to changing, building a better mousetrap. And it took a long time. It was totally worth it. And we finally got some funding. And that was just amazing. But so that was, changing how, making the hearings. So in my mind, us judges weren't fishing for the old regulations at NLRB to try to figure out how to make it work. Try to construct something that worked better, and then, put out a set of FAQs to try to explain it to people. So, I mean, that was in my mind, a real pivotal moment. I'm going to just go quickly on the second. COVID. And when we had to shut down for 3 months, I knew backlog is coming. And the cases were going to pile up. We were going to have new COVID cases that we've never had to deal with before. So with the help of, people, we set up video conference stations, and I begged practitioners, hey, let's get these cases going. Let's get these cases going, until the governor's executive order came down and we can order it. But I do remember begging. I remember saying, Judge Clossy, I want your honest opinion. Can this be done? Can you think you can make a ruling on that? My answer, I don't know. And I didn't. But if we didn't get that caseload rolling, labor relations is going to be stalled and things aren't getting resolved. So I'll give those as my two pivotal moments, Chair.
So huge. Want to go next?
Sure.
Thanks.
I'm Loretta Vanderpool. I'm a retired annuitant now, but I used to be the director of SMCS before Jerry Fetcher. And I started with SMCS in 2010, the spring of 2010. And all of a sudden in 2011, we found out at a staff meeting, actually in December of 2011, that we were moving over to PERB. And in the same meeting, our chief announced his retirement. So our chief retired, and then right after him, the second most experienced presiding conciliator, Tony Butker, retired. And then we had no warning. We didn't know what that change was going to be like. We were with the Department of Industrial Relations. We had been a tiny little division at DIR that was reasonably funded, I guess. We had lost some positions because of the state's budget cuts, but we were kind of left alone. And here we were going to go from a really massively huge organization to this small organization, and had no idea what we were doing. We knew that Anita was now the chair, because that announcement had come in a staff meeting a couple of months before that, and everybody was excited about that because we actually had a neutral that was going to be chairing the board, and that was a big deal to a lot of the stakeholders as well. But when we came over, it was in 2011 and 12 in the public sector. A recession in the private sector doesn't hit the public sector for about 2 years, and that takes longer to resolve. And so we started hitting the peak recession years in the public sector in 2010 from the 2008 recession. And for the next 3 to 4 years, we were in concession bargaining everywhere up and down the state. Concession bargaining was so exhausting that the parties it was heartbreaking as a mediator to walk into a mediation and have the union team say, Loretta, you're just going to have to send us to fact finding. We can't get our members to agree to anything. They're just tired of the takeaways. And it's not because the employers were not motivated to try to settle, because they were, but they had no money. And so we ended up in the transition coming over to PERB with a head count that didn't match the actual number of people we had on board. We were down to 6.5 mediators. I was the half because I was the chief. By a weird set of circumstances, I suddenly became the chief. But we had 6.5 people for 1,800 cases that year. It was the largest caseload we had ever had. We were traveling constantly, and there was no money. PERB had no money. PERB had no money. PERB was desperate also. They were shorthanded everywhere. Their work was going out of control. And so we ended up coming over. The folks at PERB were, for the most part, very welcoming, but not entirely across the board. And we felt like we were a very poor fit. So if you were to take one of those children's toys that had the little pegs with the little holes and you hammer, in, we thought we were the misshapen peg being hammered into an opening that was now becoming misshapen, because we didn't really fit. There was not a lot of thought given beforehand, and I think Anita probably knows this better than anybody. There was not a lot of discussion about what it was SMCS actually does. And so we didn't just mediate public sector grievances and contract impasses. We handled elections, lots of elections. We were the mediation agency for the Ag Board. We administered our own panel of arbitrators. We had conflict resolution work, and we conducted a lot of training. And so the other thing that nobody had really thought about was that we have always handled private sector work. And so this idea that in the governor's realignment plan that we were a better fit at PERB, we were sort of a better fit at PERB. Over time, we have become a better fit at PERB. But in the beginning, it was not easy. In the beginning, it was very difficult, and we had a lot to learn about each other. And I'm happy to say that by the time I retired, I felt like we were fully assimilated in the division, and that people liked us finally. But one of the biggest concerns at the very beginning was that when we were coming over to PERB, we had to make a commitment to the stakeholders out in the labor management community, the greater community, that there would always be a really rigid firewall maintained between SMCS and the General Counsel's office. There was a tremendous fear that the work that we were doing, the confidential work that we were doing in contract impasses and grievances, would bleed over into discussions with the General Counsel's office about any unfair labor practice complaints that the same parties had going at the same time. And fortunately, with some of the work that we did, we were occasionally, able to get the parties to agree to also withdraw any unfairs that they had pending. And so that was, a little bit of a help. But in the beginning, that was a real panic, even with the SMCS staff. Are we going to be pressured to start sharing information? And that never developed. It worked out just fine. So I feel like I can't remember a time anymore that we weren't a part of PERB, which is kind of strange. The first 3 years were not like that, but I had such a brief tenure before I came to PERB. You know, I was only a mediator for a year, less than a year, before suddenly I was the presiding and then simultaneously the chief. So
I just recall a time that Anita took me to an SMCS event in Oakland, and you were all very angry, and a lot of you yelled at us. So, so to go full circle to where we are now is really great.
like I mentioned earlier when I was making a speech about for Felix, we're loud. You know, and sometimes
And
sometimes
opinionated.
pain.
Yeah.
Yeah, and opinionated. Yes.
How about you, Eric Shiners?
Yeah, so my experience overlaps in some ways with many of my colleagues. I have also been a practitioner and am again a practitioner in front of PERB currently. So as you can see from my bio, I was first appointed as a legal advisor in 2008. And as Sean mentioned, you know, just right at the beginning of the recession, at that point, the board was just trying to struggle through keeping everything moving. We had some layoffs of support staff at that time. Was a very difficult time. Morale was not great. We were all, I think, furloughed almost every Friday, every month. So it was a challenge to get work done. I will say the legal advisors at that time, we had a really collegial group. We all really enjoyed working with each other, and that I think helped for us to get the work done, was just to collaborate with each other. Pivotal moments during that time, a really geeky one, we actually decided that we were going to formally adopt the California Style Manual as the style for board decisions during that time. As we were also heavy Dills Act at that time. The Correctional Officers Union and the administration were, as my more experienced colleagues at Cal HR call it, engaged in the war, where they were out of contract. And so they were filing at PERB constantly. And so if you look back on the decision bank for especially 2009 period, you're going to see a ton of Dills Act cases with the correctional officers. So we worked our way through those. I think that was my first stint as advisor, was just learning a lot and also just trying to get through the work that we had to do and keep things moving. And then I was appointed by Governor Brown in 2018 as a board member and served a 5-year term. The big pivotal moment, COVID related, was EPERB. I think for our constituents, of those of us out there, EPERB, we got it up and running just before the executive order for everybody to stay at home came in place. I think we were already behind on that project when I was appointed. It took us another 2 years, but it went into place right before COVID. It worked and still for the most part works. So I think that was fortuitous timing for us, and just also the culmination of a large project with a lot of time and resources put in by the various people in the agency to get that up and running. I agree with Sean, the case processing efficiency initiative. Again, I started that as a constituent. I came to some of these meetings on behalf of the firm I was working for and gave our thoughts. And then I got to come on the other side and help implement all the thoughts that we got from the stakeholders on those. So I think that was another pivotal thing that I'm dealing with on a regular basis, because then I'm looking at regulations and go, oh yeah, I remember working on that one, or people ask me about them, go, yeah, that does this. So from the constituents' perspective, it's made a big difference, I think, to have the results of that initiative in place now and helping everybody be more efficient, understand more what PERB is expecting from them, and what we can expect from PERB prior to that initiative being undertaken. So I think those are my main points from my PERB service.
Can I say something real quick about the furloughs? When we were mediating contract impasses and furlough days were first being rolled out at the beginning of the public sector portion of the recession, we as state employees had 3 days a month, 15% pay cut. And then followed by a year of 2 days a month, and then another year of 5 days a month. So we had 15% pay cuts, and then 10%, then 5%. In mediation, we couldn't take the furlough days. We had to bank those because we were working all those cases. And we would walk into a mediation and have an outraged group of employees say, can you believe they're asking us to take 3 furlough days a year? You know, and there's nothing that you could really say. You had to just like, you know.
That's awesome. Thank you. This actually brings up so many memories. I could just go for my first meeting with Anita, where I thought she was my first interview with Anita. She was so hard. Oh my God. You were so hard in that interview. But COVID was really, Sean, I want to say that there still are rooms in this building that are hearing rooms now because Sean didn't care. Sean just walked and said, oh, that room has something in it. We're going to make a hearing room out of it. It was really pivotal to getting us where we were today. And
COVID solved the one problem we hadn't figured out about EPERB. How are we going to get hearing exhibits into the EPERB system? And now that the parties have to submit them electronically, problem solved.
yeah, EPERB was like one of those things where I think timing actually worked because it went live during COVID and we couldn't have done the work that we did without it. But I want to talk a bit about culture if we could for a second, because, Sean brought up the case processing efficiency and so did Eric. And, that was one of those cultural shifts for this agency where we decided, let's not just take what comes at us, let's take the reins and see what we can do. As a result of that, this board, if you haven't noticed, has been a continuous rulemaking board. And we're always looking at different ways to streamline, align things, and looking at different options. And going back sometimes to the past, dusting off those LRS positions and seeing how we can use positions differently. And thank God that SMCS does private sector work and stays here because we couldn't have taken on the burden we're taking on today. But a couple things, there's one piece of PERB culture that I'm really interested in, and it's this. We're an adjudicatory agency, so you think that we want to prosecute everything. We want everything through the process, but this agency has a strong culture. It's been here since I've been here, of really working with parties to not use our process, to get things settled informally. And I want to explore that a bit. So, and I think I know where that came from, and I want to talk about people's experiences with it here and some ideas for how we can be advancing that. I think Anita, that was you that started this. Like Anita started everything.
Everyone working hard, but in my way of thinking, PERB has always had so many more cases filed that can actually be possibly formally litigated. And so I think that early on, we learned that assisting the parties in settling the disputes was a service that we could offer that was beneficial and very it was a service that we could offer and beneficial to the parties and very, very much appreciated. Personally, I think that it helped that we met in person for many years, and those settlement conferences were conducted at the employer's place of business. These meetings facilitated relationships between the parties and PERB staff and offered a neutral venue to air grievances, many times which came up that had nothing at all to do with the case that was before you. So we embraced for a long period of time interest-based bargaining principles, and we actually did trainings for the parties regarding interest-based bargaining. And I think that interest-based bargaining also brought up the number of settlement numbers. Many of you know, and some of you folks I've had settlement conferences with, and I really got a bad rap, which wasn't deserved. And, things like, she doesn't let you eat lunch or,
She makes you stay there till midnight.
well, or locking the parties in their rooms until way past 5 o'clock. but that's not true. Sometimes issues were much more complicated than at first glance. And for me, if there was even a hint that the matter could settle, I kept the parties together. That was my job. And that's quite frankly, I think what the parties expected. You know, they knew that PERB staff were dedicated employees trying to settle cases. And I think they trusted us, and it worked. So we used to hold conferences and trainings and things. And another one of the little items that I kept from my, chest of PERB items, David Letterman I was a big fan of David Letterman. And so I did this training called the Late Night Top 10, and it was about settlement conferences, what to do, what not to do, all this stuff. And it was so well received. I mean, it was fun to do, just because, the whole, if a lot of you are too young to remember David Letterman, but he did have this piece in his show where he would do top 10 things. So firefighters walked me to my car at midnight in downtown Oakland. We were there from 10 o'clock in the morning till midnight. We got a deal, and it almost fell apart many, many times with Margot, with Ari. We had with Priscilla, long settlement conferences. And I wouldn't give up. Some people want to throw in the towel and really quickly, and I do not. And when it's time to cut it, you cut it. I mean, that's obvious. But I did have the reputation of really, really trying to get the settlement. And I know that lots of PERB staff, while I was doing settlement conferences, did the same thing. And I'm looking at Val and Eric. So I really, really strongly believe in the settlement conference process. And I'm hoping that it's as successful today as it was in the past. I've been retired for 10 years, so I've been away from PERB for 10 years. I don't know what your numbers look like, but I'm hoping that they're high and that a large number of your cases do settle. And it's really on the PERB agent to take that control and figure it out. One of the things that I have a problem with about what's happening today and how things are done is I don't know how, I guess I like to look at people face to face, look at them in the eye. I really can tell a lot from a person's body language. And today, now that you do them on Zoom, I guess most of them are done by Zoom. You don't do them, okay, you don't do them in person. Anybody could say, hey, I'm done. Click. What? That wasn't going to happen with the person or the parties in the room. And, I know that you probably won't go back to doing them in person, but it's like mediation, again, the value of having the body in the room or bodies, and to have them look at each other and talk about their dispute. Because a lot of the time the PERB agent should step back and let the parties, communicate. I just don't know if that's been lost or if you guys have figured out a magic way to get that into the process. I personally formed many professional relationships with the parties that I think facilitated frank conversations, some off the record when disputes arose. And I think that the parties knew that they could trust me. Thank you for that. Um, let's see. So I, I really hope that settlement conference, the process is still strong and vibrant and utilized. And if there's a way that you can do any of them in person, I think you'll see what a huge difference being able to talk to people, relate to people, will make. And, maybe the numbers will go up. I don't know. But that's what I'd like to contribute to that.
So if anyone wants to add anything to that, I'd
I,
invite you to, because then I want to make sure we move on to the line.
yeah, I would like to add very quickly that what Anita has described is the way SMCS operates. And so, I would tell people as soon as I started a mediation, we're not scheduling a lunch. So you folks have plenty of time to grab something to eat during your caucuses, but we're going to work straight through. And it's not unheard of during really difficult impasses to work around the clock. So we've had some of those 18 and 24-hour, cases. And I wholeheartedly agree that impasses, especially, which are similar to in difficulty sometimes to some of the informals that the GC's office does, they really do need to be done in person, because you have to be able to read body language, but you also have to be able to read the leadership in the team.
Absolutely.
So you're not always going to be dealing with the true leader of the group. If you're watching them on a screen, you can't read that there's something else going on. There's a dynamic within the group that, if you were in person, you would be looking at somebody different, someone other than the person who's doing most of the speaking, because that's your informal leadership in the room. So the body language is important. You can figure out if some of what you're saying is having an impact, or if it isn't, and you need to change strategy, and you miss that on a screen. So a lot of our cases are easy enough to be able to do on Zoom, but on the complicated stuff, it's really important.
Complicated cases like Bart.
Anita and I got lifted out of what we were doing and sent to work of the BART contract impasse. With Governor Brown sent out a letter saying, I'm putting the state's top 2 mediators on this. And I'm thinking, well, that's not me. I'm not, I'm pretty average actually, but I was working, Margot is here, Margaret Rosenberg, and I was actually working with her on their contract impasse when I got lifted out of that one, and we had to move somebody else in behind me there. And we had 2 viable strikes that were being threatened at the same time. And it was a hair-raising time because we were also dealing with a lot of other strike threats throughout the state. So I was at Bart, Anita and I, and we spent 4th of July holiday there eating trail mix while our families were sending us pictures of hot dogs and baseball games. And it was very uncooperative. The whole situation was kind of uncooperative. But we had a lot of strike activity going on right at that particular time. So I was spending my midnights in my hotel lobby meeting with other mediators, debriefing the cases that they were working on. So it was very, very, very fraught, that whole situation. It was tough. It was fun though. Kind of.
So I want to thank you, Loretta and Anita, for raising a controversial issue of how we do mediations, whether it's in person or online. Thank
Well,
you.
are you guys
I think it's a
talking
mix.
about that?
It's a
or-
mix.
I don't know.
It's a mix. And I think it's also, my understanding is the parties do have a say in it.
The parties?
The parties, are a part of it as well.
Uh-huh.
I know all the federal mediations are being done remotely because not all of them are now.
Nope. I do in person if I can get there without charging PERB any money.
See, I don't know everything. So here we go.
So just to answer your question,
Please.
since I live in the Bay Area, I can take BART on my senior BART card. That's me in retirement.
You get one of those.
Anyway, I have found that the parties in grievance mediations, I haven't done anything beyond a grievance mediation. More often than not, they do appreciate the in-person attention. Sometimes, however, they do say, I need it remote because the grievant lives, in Sacramento. And so, he or she is not going to be able to travel into the inner Bay Area. But,
especially when your attorney's charging you the travel every hour.
I'm not traveling. I'm not
No,
traveling.
no, 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 no. So I want to move on to the last and final question here, and I think it's the whole discussion of SF BART plays in here, because back when you were mediating that was not under PERB's jurisdiction, but the BART Act is now one of the many statutes that's now come under, and I think we've talked about this, and I know all of you, and I know you all have opinions on many things, but this agency is growing and changing dramatically. I know Anita and I have had some really great conversations about TNC Act and how's it going to work. And she's like, what are you going to do? I'm like, we don't know. We're figuring it out because we don't know. Every new statute that comes on, we expect a lot of work, and then sometimes it is and sometimes it isn't. We're on the cusp now of July 1st. We do get jurisdiction over the legislature's employees. TNC comes on, and we're actually in the midst of working on that. AB 288, what I call the NLRB trigger law, to some degree, right now it's enjoined, but if that ever moves forward, and I don't see it stopping. I don't see PERB is now in a position where we're seen as being able to handle the work, and we're because of the CPEI and the mission-based review that we did during that with the Department of Finance. We've gotten pretty good at making a justification for resources. And we never want to be in that MMBA situation again, where we double our jurisdiction without the resources to match. But given the fact that we're probably going to keep growing, and knowing all of you have opinions, we'd love to have you give some advice to us on the things that you think we should be thinking about or looking at as we continue to grow as an agency. Sure.
I just want to say the most valuable asset of PERB is its employees. And what I mean by that is that we've been confronted with, I'll just say the MMB. We talked about the bargaining, concession bargaining, and the employees like to talk about solutions and what will work. And there's usually one, I'll say, volunteer. Okay, I'll hear that first case. And then we all try to figure out what to do. And there's a certain amount of consultation that always goes along. And I just think, in a sense, that, as long as you continue to have that reforming attitude, introspective attitude on how can we change things, and people that are willing to make those changes, that seem to find a way. And if you think about it, I mean, in those that are at this panel, we had some pretty tough backlogs. I mean, really tough. And I remember, and we climbed out of them. But it takes a lot of effort, and it takes a lot of listening to the people. I've always felt about PERB that you gotta like people to work for this agency. You can tell by listening to Anita, she likes people. And if you don't like people, it's hard to work for the GC. It's hard to be a judge. It's hard to communicate that as you're trying to move things along and move, I'll say, the agenda. So I'm very positive that the way that we've had this culture and of, I'll say, introspective, and how can we build a better mousetrap? How can we adapt it for this part? That PERB always gets there.
I don't have much sagacity to offer on this because I was never the chair of this board, but it occurs to me that what has made this board, not only when I sat on it, but continuing successful, is that you collectively, perhaps Eric, particularly you, since you're the chair, have kept an open relationship with the powers that be in the governor's office, so that and the other things that Sean had mentioned, doing the efficiency, the case management efficiency initiative, showing that we can adapt and can become more effective. Passing the regulation that not every decision has to be precedential. That was a big one, I think, in reducing the backlog.
Big fan of that one.
Yeah. Anyway, it demonstrates that we can change, adapt, and use the money wisely. And so just the, you know, the politics, for lack of a better word, of keeping an open conduit of communication between you and the labor management, whatever they're called now, you know, what are they called?
LWDA.
Yeah, yeah. Will help grease the wheels to get the funding that you need, hopefully.
Yeah, I agree with Sean. There are a lot of smart people who want to get things done and figure things out. At PERB, that was part of the enjoyment I had both times around here, was just people who want to figure things out and make things move forward. And PERB at this point is still at a size where it can be nimble. I'm now dealing with some of the largest departments in the state who have had things ongoing for years to try to change certain things about their program. And, you know, it's like trying to turn a big cruise ship, you know, on a dime. It's very difficult. So I think take advantage of the fact that PERB is of the size that it can still be nimble enough to proactively address many of the things that are coming its way. Not every department has that ability.
And one of the things that I thought that I actually wrote down was make your presence known. You know, be very proactive in doing outreach ahead of these new people coming over to PERB. There's an opportunity to introduce PERB to these new stakeholders and to let them know not only what it is that PERB does, but what it is they can do. You know, that they ought to be engaging more in informal settlement conferences, that they ought to be looking for ways to cooperatively settle some of their cases rather than litigate. So right now, having had primary contact within the public sector, there are conferences and there are forums that deal with public sector management and public sector labor unions. But you know, finding where those places are that you would have the biggest impact to talk about PERB out in the private sector would be a really good start, I think.
Of course.
I just want to get back to the staff and what the agency can do for the staff. I think it's really important to mentor new hires, especially with all of the different statutes that you've got slamming at you. For new people who have no idea, they need mentors, and maybe you're doing that, I hope. I would really advocate that the divisions meet on a regular basis. Maybe you're doing that so that you have a sense of community. You know, you get to know your strengths and weaknesses within your divisions. I think that's really important. I would suggest that, as we did in the past, that PERB think about partnering with Berkeley, with UCLA, with Davis. I mean, they have all kinds of items that you know, we could, you know, do something together, and do conferences or trainings for the parties, especially when you've got these statutes that everybody's scratching their heads going, what the hell? Like, what does it mean? To you know, get down into the nitty gritty and do some trainings, I think would be great. I don't know how you do this if you don't meet with the parties in person, but you know, I wrote down, get to know the parties and build relationships. That is so key to me to how you cut deals and how you make things easier for the parties and for as a whole. Because if I can pick up the phone and call a union person and really let them know what the nitty gritty is, and just, you know, as a trusted, you know, friend, professional, it really makes all the difference in the world. So I think building relationships with the parties, and again, I don't know how you do that via Zoom. I really don't. And maybe you guys have figured it out. And if you have, give me a buzz because I really want to know. I think one thing that's really important is to preserve your reputations as competent, fair labor relations professionals. And I think that staff need to keep focusing on quality and following precedent. And I'll end with stay focused on your neutrality. Your job is to implement these statutes. It's not to advocate for one party or another. It's to, see the merits or no merits into what's filed. And it's your job to, then deal with things appropriately. So that I think is really, really important. Neutrality.
Well, we are at time. So I want to thank you all for being here today. Anita, Sean, Priscilla, Eric, and Loretta. It's always wonderful to have you back. And Priscilla and Anita and Eric, so great to share the dais with you again. It's been quite some time.
Wasn't my usual spot, so it's very strange.
I think this was my original spot, actually. So down at the end. But so I want to thank you all for being here. Please keep in to many of these things to Anita and Outreach and Loretta and Outreach. We are doing Zoom meetings, Zoom webinars every single month through this, and we'll be doing another one in Oakland in June. So please sign up. Go to our website for PERB 50 Forward. All the events will be listed there. So please thank me. Please join me in thanking my panel for today. Really do appreciate you for being here.